Hello, how are you doing? You're welcome to Lawyers Info Hub. It's always a pleasure to have you on this platform. So today we're looking at amendment of pleadings, understanding the modalities. How do I go about amending my pleadings? How do I move the motion? Or how do I prepare the processes? And all there is to amendment. Are there exceptions? Are there things I can't do when I'm amending? Now, let's get it rolling. If you're yet to subscribe to the channel, please do hit the subscribe button. Join this beautiful family. Join us as we, expand our legal knowledge. We believe that knowledge is that light that puts away every ignorance, that brings about obstruction to your career path. Join us in today's class and you will love it. We have other contents that will be beneficial to you on our channel. Go through the channel, we've churned out lots and lots of informations that are very crucial to for your excellence and for you to be knowledgeable as a lawyer, as a law student. So let's get to class. What is amendment? We know all what is that. After the pleadings have closed, a party can also choose to amend the pleadings in terms of the statement of claim or the statement of defense, because of one or two things. You can amend, maybe you're trying to add parties. You're trying to add another witness or claimant, or want to add another defendant. You want to amend, maybe there are new facts. You want to amend, maybe you want to add more witnesses. You want to amend because maybe sometimes when a party changes counsel and the new counsel comes in and says, I don't think the way these prayers in the reliefs are couched are well represented. I need to do something. Or the lawyer looks at it and say, no, there's some things we need to add and subtract. You can apply for motion for amendment. Maybe a party dies and you need to substitute. There are reasons, lots of reasons for amendment. There are lots of reasons for amendment. Now, looking at the modalities, how do you go about it? when you want to when you want to file the application for amendment, you first thing to do is that you work on your process that you want to amend. You must have looked at and added the things you want to add. Is it with the parties and then the body of the work? Then you need to underline it. Looking at what you have before and what you need to add. So the things you are adding, you underline it, because that work you just did will be an exhibit to the motion you're going to move in the court. So when you call it the proposed, it could be the proposed statement of claim or the proposed statement of defense, as the case may be. So when you file in your motion, the prayer will be for an order granting leave to the claimant or to the defendant to amend either their statement of claim or the statement of defense in terms of the proposed amendment. Remember that what you have worked on, that's the proposed. What you want to add, that's the proposed statement of claim or the proposed statement of defense, including which will contain what you need to add, will be an exhibit, so that the court will look at it as, okay, now I see the things you want to add. So the other party can also look at it as, okay, adding, you're moving this from here and putting this, and those new things you're adding must be underlined. So you're going in your prayer, I note that you are attaching the proposed amended. It could be a statement of claim or statement of defense in support of the motion and marked as Exhibit A. So in general, your prayer will be an order for leave, granting the claimant or the defendant, leave to amend their statement of claim or statement of defense in terms of the proposed amended statement of claim or statement of defense that is attached to this motion and marked as Exhibit A. And for such further orders, if there are other things you need to, okay, maybe you're praying for additional new witness, you can pray for an order granting leave to the claimant to call additional witnesses. So whatever the prayer is has to be included in on the face of the motion. Then you date it, you put in those who are executing. Now you remember that the motion will have to come with an affidavit. The affidavit is now where you're stating the reason why you want what amend? What are the reasons why you want to amend? Sometimes many people, it is very tidy to also state the grounds upon which your motion is being brought. That ground is usually after the prayers on the motion. Maybe what are the reason? Maybe a party has died, you need to substitute, or there is need upon a thorough preview or perusal of the processes. You as the new counsel have found need, to amend, so as to align the evidence with the facts of the case. Whatever it is, the reasons are that no grounds for which you're bringing the emotion. Then you have your affirmation. So is it like an extension of your ground where you have stated to the court why you want to amend? Remember that proposed amendment, that amendment of the what shows what you want to add, it will be an exhibit. It must be an exhibit. Court where a counsel is moving an application for amendment, the court is asking where is the proposed. And we have also seen where a counsel is moving a motion for amendment, and he has gone ahead to even file what he or a clean copy of the proposed, asking the court to deem it. It's not done that way. You first of all move your motion. Remember, your motion will have a written address where you bring in what are the rules of court under which issues of amendment of pleading comes in. Then the fact that it's a matter of discretion, and the court should exercise that discretion judicially and judiciously. So these are the contents of your amendment, of your written address in support of your motion. Now, and also considering the stage of the matter. These are the things the court looks at in also granting your application. The state at which you're also bringing it is also very important. So you can put up those arguments in your written address in support of your motion, which I've already told you that the proposed amended pleading will be an exhibit. Now, in law, in practice, you can amend your pleading at any time before close of what case management conference, or what we call the pre-trial conference in some jurisdiction. You can amend at any point in time, but once you get to after the close of the case management conference or the pre-trial conference, you cannot, which is now you're now moving to trial, you cannot amend more than twice. Why this is, you cannot amend more than twice during trial. Why this is so that you don't make the court lose track of what you're doing. Today you're saying A, tomorrow you're saying B, you want to change. So before you close of CMC, you can do amendment. But once you move into trial, the court cannot allow you more than twice to amend. And once you are bringing a third amendment during trial, the defendant can raise it, or depending on whoever is bringing, the other party can raise an objection to such amendment, because it's more like you don't even know what you're doing. Why are you changing, the facts, or why are you trying to tilt, or because you have seen how the trial is going, you want to change certain things. Now, it's also very important to know that I've told you that your application is by way of motion, and you bring a pursuant to depending on the jurisdiction you practice, the rules of court guiding that jurisdiction. There's always a provision in the rules of amendment. So you bring that your motion in line with the rules of that court. Then under the hearing jurisdiction of the Honorable Court, you attach your affidavit and I tell you that the exhibit will be that amended process you intend to amend. That is the exhibit, which is underlined, and the title will be the proposed amended statement of claim or statement of defense, showing the new thing. The new things you are adding will be underlined, very importantly. Then your written address. Now, when you on the day you have served the other party on the day to be heard, you move your motion. Now, sometimes when you file your motion for amendment, the other party may file a counter, and most of the time people come to court to say, "Well, amendment is by the discretion of court. Why would you want to object to amend? I might have a right to amend." Now, why you want to amend? Why you're trying to amend? You must not move out of boundary. There are things you cannot do. While you're amending, you cannot change your case. Do you know that is one of the exceptions? You cannot what change, you cannot what change your case. When you change your case entirely out of what your initial case is, the other party can raise can file a counter affidavit to say, my Lord, do not grant this application. I've had cause to be in that situation where I filed a counter and the court, listened to me and I wanted cause. They said, no, I cannot allow you to change your case because the claimant, for example, who's trying to amend his plea or his statement of claim, have seen the statement of defense and have seen where your defense is. Now you're trying to amend so that he will overreach the defendant in his defense. So that way, you urge the court, you cannot amend. It's one of the exceptions in amendment. You cannot amend to change the nature of your case. Once you have changed the nature of the case, the court cannot oblige you. There are plethora of cases that rule states that where in your course of amendment, you're changing the nature of your case from saying A to B, you are going to overreach the defendant, and the defendant will show that how it's going to be overreached. Very key. So these are instances where the other party can raise a counter can file a counter affidavit to say, my Lord, I'm opposing this application. I'm opposing this application. Also remember that when you amend your plea, for example, your statement of claim, it also invariably means that you're going to file a new statement. We file a new statement on oath, which will not be, uh, a further witness statement of the claimant's further witness statement on oath, no, or additional, depending, what there, it will change because what was there before is not what will be there now. Do you understand? So it's very important you know that thing. You do a further written witness statement on oath. You also note that you have to add the list of witnesses. Prevention, the witnesses are changing, you need to include it. Even if it's the same, still add your list of witnesses and list of documents. Remember, when you have amended, the court will no longer have recourse to the old pleadings. So you have to be very careful. So when you are filing your fresh, so for example, amendment statement of claim, you need to put in your list of witnesses, list of documents as it should. Very, 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 very important. Very, very, very important. So don't leave it out. And you also look at your documents. Sometimes in your addition, you're making reference to other documents. Ensure that you're adding those new documents you have referred to. And you must note that many a times lawyers have made a video on how to drill, how drafting of your plea is very key. That's one of the primary things you must learn as a lawyer. Sometimes you see when a lawyer will plead to document his statement of claim. Now his witness statement on oath, that document is not pleaded. Sometimes trial, some courts allow it, but some other courts say, why didn't you plead it? The documents are in your statement of claim, but it's not witness statement on oath, which is even what your witness will adopt as his evidence. So ensure that all the documents that is on the statement of claim or the statement of defense also reflects in the witness statement on oath. Very important. So we've talked about amendments, talk about the modalities of how you file application, how it's going to look like, and what your prayer will be. We have also talked about um, the need for you to attach that proposed as an exhibit. Very also important to note that once the court grants your application, it's important you now file a fresh, pleading in terms of reflecting those things you underlined in a clean copy. Reflect it in a clean copy, and file it. Now, it's very important that after amendment, that amended process will carry on the top of it, amended pursuant to the order of court made on dash day of dash 2003. Very, 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 very key. Amended pursuant to the order of court made, it must be on the amended process. We've seen people raise objection on the fact that even after a parties have amended, there is nothing on the face of the process showing that the court ordered or the court granted leave for such amendment to happen. So when you're filing your fresh process on top of the process, it will show amended pursuant to the order of the court made on the dash day of dash 2000, state the year. Very, 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 very key. And you file it. Now, most of the time, you've seen where court makes an order for amendment and the court directs that parties, like the defendant should file consequential amendment and the claimant should file a clean copy and all that. Then the other party should file consequential amendment. Now, in some rules of court, it has been stated, well, and many jurisdictions are following suit. When the court makes that order that you should go and granted to file a clean copy while the defendant or the other parties file consequential amendments. After, like in my jurisdiction, some other jurisdictions, after 7 days, and you fail to comply with that order of court, you're supposed to pay cost. Some rules of court has clearly stated the cost of what you pay after 7 days if you don't comply. So not after the court have granted you leave to amend, you now go and sleep. It's not done that way. So you pay cost after 7 days, and as a defendant, you're supposed to also file consequential amendment in line with what the claimant, for example, has amended. You file yours, reflecting your defense in that manner. So it's very important, most important, the power of course to amend, but don't overreach the boundary. Don't change the nature of your case in trying to amend. Court will not grant that. Yeah, so I just hope you've learned something today on the issue of amending the modalities and how to move it. How to move your motion for amendment is the same thing as how to move your motion. My Lord will have a motion for amendment dated and filed this day. My Lord, we are praying for you that what your prayers are, and the motion you brought pursuant to. We have supported with an affidavit of 6 paragraphs where we have one exhibit. We learn on all the advancements that are in the affidavit. We file the written address in support of our argument with respect to this motion, and we urge the Honorable Court to grant our motion. Very simple. When you're in a situation where the other party files a counter, in that respect, the other party will be given opportunity to what also adopt their counter. The court will rule on whether you should amend or not. So, friends, I just hope you learned something today. If you have any question, drop it in the comment section. We will attend to it. Thank you very much.